So we've looked at the sources of law and where to find it and how we might read the law. The next two sections that we're going to deal with is how the law operates, or what are some of the issues that you need to look for when you're reading the law to understand how it operates. So that's separated into two categories, the 3 and 4 here. The 3 is about how cases operate and why you've got to look at certain parts of the cases to understand what the law is. And the second bit looks at statutory interpretation, which is what happens when you're reading a statute or a piece of legislation and it's unclear. How do you work out what the law actually is? So let's do the first of those, the doctrine of precedent. So we'll remember that a key element of the common law system is this idea of having judge-made law or case law. And we'll remember that we actually use the term common law sense to mean this case law. So this means if it's going to be the law, that those judgments need to be recorded and published. Okay, so and we've just gone through where we can find them and how they're set out and what's in those judgments. So the doctrine of precedent is the idea that if a court faces a case with similar facts, they should follow the earlier decisions of other courts that are higher within the same hierarchy. Now, this is why last week we spent so much time, or there's so much material around the court hierarchy, because it's only decisions of other courts that are higher within the same hierarchy that we're bound to follow. And that is the doctrine of precedent. As a result of that, we get consistency in the application of the law, and it's based upon that idea of fairness and justice that similar decisions should be made in similar situations, that the same problems should have similar outcomes. And that's one of the ways that we get that certainty and fairness in our law. So here's a simple example that comes from contract. Imagine we have two parties, Jamal and Kate. Kate's lawyer argues that Kate doesn't have to repay some money she owes to Jamal because Jamal verbally promised to forgive the debt. Jamal's lawyer argues that a promise to forgive a debt is not legally enforceable unless the promisee gives something in return. When we come to contract, we'll realise that this is one of the rules around consideration that's developed, right? That if you're going to have a bargain under contract, there must be an exchange of something. And so what Jamal's lawyer is arguing is that Kate has not given anything to Jamal in return for his promise. And because it's just a promise, not a contract, Jamal can break that promise. So this leads to an issue. There's a question of law. Is a promise to waive a debt legally enforceable, particularly when nothing was given in return for the promise? Now, there's no legislation on this, so there's no code or no law you can look up in a statute. So the judge is going to have to look at what other judges in the past have decided. The judge is going to have to look at precedent. Now, when we're talking about precedent, we also have to realise that it's only the intermediate and superior courts. What does that mean? That means the courts higher up in a hierarchy can establish binding precedents. Why? Because it's only binding on those below them. Okay, so it has to be in one of the superior courts or the intermediate courts. A judge is only obliged to follow the decisions within the same court hierarchy. Okay, so it's about, if you're in the federal court hierarchy, it's only those judgments up that hierarchy. If it's in the Queensland hierarchy, it's only the judgments in that hierarchy. Now, you'll remember, though, that on top of it all is the High Court, which is the last court of appeal in all of our court systems. So really important precedent is set in the High Court, and that's why it's so influential. It's the highest court that influences all of the hierarchies within Australia. Decisions of courts outside the hierarchy are not binding, but they can be persuasive. Okay, so that means the judges take a lot of notice. So here in the Queensland hierarchy, they might take a lot of notice of what was decided in a federal court. They don't have to follow it, but they may take a lot of notice. Ratio decidendi is a Latin term, and it's the reason for the decision. It is the part of the decision that's binding. Now, the judge can also issue some other proclamations, right, or make some observations. A remark that's said in passing is called obiter dictum, and that is not binding, right? It's only the key legal rationale. Hopefully we'll have a little bit of time to discuss that in the workshops and lecture as to why that's the case. But the really important thing for us to remember here is it's only the ratio or the reason for the decision that's binding on those lower courts. So let's simplify what the doctrine of precedent said. Courts must be within the same hierarchy to be binding. Higher courts bind lower courts. A single judge is not bound to follow the decision of a single judge of the same court, but is bound to follow a decision of the full court of the same, because it's a higher up in the hierarchy. So that is really the essence of the doctrine of precedent. So all we have here is a diagram setting out, the hierarchy and the difference between when a court might be binding versus persuasive on another. So let's have a look. So, of course, the local magistrates court, they're going to be bound by the intermediate district court, by the superior courts of the Supreme Court, by the High Court, etc. Because it's at the lowest end. It's the lowest in the hierarchy. So all the courts in that hierarchy will be binding on it. And as we go up, right, less courts become binding. So if you're in the district court, okay, it's only the appeal division, or if we get up into the Supreme Court and the High Court that become binding, and so on, right? So you see it depends where you are in the hierarchy as to what's binding. You will also notice that if we're in this Queensland hierarchy here, what we can see that the federal court, at the family court, right, these arrows are saying persuasive. These decisions here, particularly in the higher courts, the full court of the federal court or the full court of the family court, if they're relevant, they would be persuasive into our hierarchy. Atop it all, the High Court, which binds all of our hierarchies together. Now, look, just for a matter of to understand history and some of the cases that we'll come across, the Privy Council, which was the highest court in Britain, used to, up until the 1980s, sit above the High Court. It now doesn't, okay? But we have a long tradition that our law has incorporated older cases that come from these British courts, and the highest courts in the UK, but also say even in the US, judges might look at their decisions, how they decide a certain issue, but those decisions will only ever be persuasive, not binding. Okay, hopefully that gives us a bit of an insight into how that doctrine of precedent works. Next up, we're going to move away from looking at court cases and how they operate and move into legislation and statutes and the problem of statutory interpretation.